Ms. Shen alleged she had claimed that she had a forced abortion, and that it all came out because she went to go get a marriage certificate in China, and she had to do a pregnancy test. And to get the marriage certificate, she had to undergo this test, and they found out she was premarital pregnant and forced abortion was the claim. The immigration judge found her not credible for a variety of reasons. But the BIA only affirmed on 2 of them, meaning there were only 2 reasons up before the Ninth Circuit, importantly. One of them, the Ninth Circuit didn't believe all that important, so we're down to the last one. The last one being this. On cross-examination, DHS, the ICE attorney, was saying, isn't it true that, I want to say it's in 2010, no, 2003. Isn't it true that in 2003, the year that this marriage appointment to get a marriage certificate happened, isn't it true that China changed the law and you didn't have to go to an appointment like this anymore to get a marriage certificate? And Miss Shen, she was kind of flustered, and I mean, clearly it was not doing well, and she was nervous, clearly, and said, oh, you're right, I'm sorry, it wasn't required. And so that the immigration judge really picked up on this and didn't like that she was inconsistent about implying that she had to go to this interview, to get the marriage certificate that resulted in the abortion, and that then now she's saying after cross-examination it wasn't mandatory. Query why it matters, because she still had a forced abortion is the claim, but put that aside. But the Ninth Circuit did its own analysis, its own legal research into foreign law, and found that actually the change in law in 2003 happened, I want to say, like in October. So months after Ms. Shen went to it. So it wasn't the case that China had changed the law at the time she went to this meeting. And so this is what's important. So the Ninth Circuit says DHS was improper in its cross-examination, and the immigration judge was improper to believe that was inconsistent, even though Ms. Shen was kind of inconsistent when confronted with it. And to me, this means this. Cross-examination in any court in removal proceedings is the worst time of any attorney's life, because they're just sitting there, mostly helpless, as their client just gets wrecked. Now, you prepare your client the best you can.
Yeah.
But ICE learns how to cross-examine. You are not powerless, though, and we have all of the objections that are given to us under the federal rules of evidence. And the Ninth Circuit here, for Ninth Circuit practitioners, is saying ICE can't cross-examine just by making stuff up. I don't think ICE made up this. I think they were just sloppy or didn't care about what month in 2003 the law changed. But if counsel had known what month the law changed in this case, counsel could have objected to the cross right then and there, and that should be sustained based on this decision, Shen v. Garland. ICE can't cross based on made up or incorrect information. And with any cross-examination, and certainly ICE, I've seen it, sometimes they're just a bit sloppy in their facts, seeing what the non-citizen will say. That's on the line. Is that proper cross-examination? There's a lot of leeway given on cross-examination. It goes both ways. But, rein them in. Objection, facts not in evidence. Objection, misstating the record. Or in this case, objection, making stuff up.